over to Bailey, who's going to introduce our guest speaker and MC the rest of the event.
Such as it is. So we are lucky tonight to have Tom Devine and the staff of GAP. Tom Devine is the GAP legal director. He's worked for the organization for 39 years, so he brings a wealth of experience to the discussion. He's assisted in over 5,000 whistleblowers in defending themselves against retaliation and in making real differences on behalf of the public. He has helped shutter accident-prone nuclear production facilities. He's rebuffed industry ploys to deregulate government meat inspection, and he's blocked the next generation of the bloated and porous Star Wars technology, which was going to turn the deficit into, I don't know, a hell child, which it already is, but that's a different subject. So he's been a leader in the campaigns to pass or defend 20 major national or international whistleblower laws. So he brings a great deal of credibility and intelligence to the discussion. Our hope is that this opens a window for people who feel compromised and they no longer need to feel that way. All they need to do is make a phone call to the Government Accountability Project and they will have a confidential statement taken. So Tom, welcome.
Thank you, Bailey. Thanks for coming out tonight, folks. It's a real honor to be speaking to an organization like the Civic Federation, and I just didn't have the slightest hesitation about accepting this invitation because the subject is just so compelling. Like probably almost all of you, I'm a parent, and if these things were happening to my children, I couldn't think of any worse development in my life. And that kind of brings to having a speaker who's a lawyer for whistleblowers. And who are whistleblowers? Whistleblowing, like truth and beauty, is all in the eye of the beholder. Depending on my own activities, if you blow the whistle, you may be my savior or you may be my worst nightmare. So I think it's good, since I'm a lawyer, I'll define my terms tonight. The people that we help at GAP are citizens who use free speech rights to challenge abuses of power that betray the public trust. That's the people that we serve. And I just can't think of any abuse of power that more disgustingly betrays the public trust than teachers preying upon their children. We're going to divide this presentation into a few parts. And the first part, which is the main part, is what we call Know Your Rights. There's not a lot of folks in the audience who are eligible to be whistleblowers as employees of the Montgomery County schools. But you're ambassadors to the teachers at the schools, to the staff at the schools that you know because they've helped you with educating your children. And a lot of folks who may confide in you are going to be very, very nervous. And we just think that it's a good idea, healthy, that everybody knows what their rights are in challenging these abuses of power. Just to kind of summarize what I'll be skimming orally, we put together a little memo. It's a Know Your Rights memo that you can have for yourself or for anybody who talks to you and is nervous about speaking out against the unspeakable. There's basically 4 sets of legal rights that apply to potential whistleblowers in Montgomery County schools. The first is a new law that went into effect last October, and it's in response to the loophole that Brian is here tonight proved by better experience, the loophole in the state whistleblower law. potentially the loophole, at least currently the loophole until he wins his case. This is a fairly good whistleblower law. It's called the Public School Employee Whistleblower Protection Act. You'll find it in section 6-901 through 906 of the Maryland Code. Maryland Code 6-901 to 906. And I'll just share with you a few of the rights that this gives to potential whistleblowers. One is, it goes beyond school teachers. It covers all employees of the Montgomery Maryland public school system. The second is it protects against active and passive retaliation. So it's not just if somebody fires you, if they refuse to give you training, if they refuse to give you promotions, you get stripped of your responsibilities. Those types of discrimination are illegal also. It protects you when you threaten to blow the whistle. You don't have to make the actual disclosure. And you don't have to engage in threats. Say, I'm going to turn you in. If you're challenging misconduct in a way that sparks fears that you're liable to go the next step, and there's retaliation against you, that's illegal. You don't have to have made that next step. The scope of protected activity is a lot broader than just sexual abuse of children. And that's wonderful. It mirrors what's available to federal government workers. State employees and public school teachers or other school employees are protected if they disclose any illegality, gross waste, abuse of authority, gross mismanagement, or substantial and specific danger to public health or safety. So that pretty much covers the gamut of abuses of power that can happen. If an employee files under this law, they're entitled to injunctive relief, and they get access to court with a jury trial if there's more than $15,000 at stake in the case. Those are all pretty good traits. Most state whistleblower laws are very dangerous, though. I usually label them as Trojan horses, kind of traps. We historically have actually advised people against exercising their rights under the Maryland state whistleblower law that Brian was kicked out of. I think the school teacher law is actually quite a bit better. But even the school teacher law has some real serious landmines and traps in it. The first is that in order to trigger your rights, you have to have first made a written dissent, written whistleblowing disclosure within the school system. So that means that there's no provision in this set of rights for people who are acting confidentially or anonymously, and then were discovered. You have to out yourself before you're even eligible for the rights. The second thing is, you only have 6 months to act on your rights after you're retaliated against. And in my experience, a lot of people don't even know they have rights for the first 6 months, let alone find a lawyer, recruit a lawyer, which can be its own campaign, and then give the lawyer time to adequately prepare to responsibly challenge you. It's not enough time. The third thing is, when you win, you're not necessarily entitled to get damages for the direct or indirect consequences of the retaliation other than your back pay and getting reinstated. And when people are harassed as whistleblowers, the damage is a lot more intense and a lot broader than just losing a paycheck that can be reimbursed. In fact, it doesn't even give you the interest on your lost wages. And what this means is that you can still lose by winning, even if you prevail in asserting your rights. The next thing that's a landmine in this law is what spooks me the most. And people should be very careful before filing suit under this law. That if you lose the lawsuit, the judge can order you to pay the school district's attorney fees. And government institutions generally don't hire cut-rate lawyers. And it could mean that you're risking bankruptcy by trying to assert your rights. It's a real trap in the law. And the final problem with this law is it doesn't cover contractors, and it doesn't cover volunteers. And a lot of times, these are the folks who know the most. It's not a bad whistleblower law, but it is treacherous, and be very, very careful before filing a lawsuit under this. The second aspect of legal rights is what we call the Maryland public policy exception to the at-will doctrine. This is something that comes out of common law, dating back to the Magna Carta. Common law is like what, if there's a negligence or there's a car accident or something like that, and you sue for damages, that's common law, not passed by the legislature. It's kind of rights that we've had to resolve disputes for centuries and centuries. And the at-will doctrine is just what it says. You can be hired or fired at will, total power to the employer. But there's a public policy exception if you're fired or harassed for defending the public against abuses of power. What are some of the characteristics of this right? The first is you have 3 years to file a lawsuit. So 3 years versus 6 months is a lot better. The second is that you can go to court and have a jury trial, get injunctive relief, and punitive damages. So you can actually punish the individual wrongdoers who did this to you. But there are a few problems with it. One is you can't get your job back. All you can do is get damages. So you can get some financial compensation, but your career is still over. A second thing is that it doesn't apply if you already have a state statutory remedy. So in the case of sexual abuse in the Montgomery County schools, the teachers and school district employees do not have access to this right. But school contractors, they would have access. So this is sort of like an alternative option for the people who don't have access to the state's whistleblower law. And then finally, the Maryland state whistleblower law says you don't have any rights unless you first disclose everything to the school district. The public policy exception tort says you only have rights for making disclosures to law enforcement or government bodies. If you make the disclosure to the school district and you're fired before you go into the government, you blew it. It's too late. You were fired before you had any rights that kicked in for you. And this kind of shows to me and illustrates exercising your legal rights is like running the gauntlet a lot of times. You have to have a skilled navigator to get you through that. But what's the third legal right that's at issue here? This one isn't available to the contractors necessarily, but it could be. It could be available to everybody, and that's the Constitution. The First Amendment to the Constitution bans retaliation for exercising free speech rights. And if the government retaliates against a private citizen under a law, Supreme Court decision we've had since 1971, Bivens versus 7 unknown agents, the private citizen can sue the government worker, the individual government employee, for violating their constitutional rights. And this is going to apply to teachers. It's going to apply, it can apply to a contract, not as a contractor, but as a citizen. It can apply to families. If your family is protesting harassment in the schools and all of a sudden your kid starts getting picked up, or there's mobbing, other children are picking on your own youngster because there's been some behind-the-scenes work, commonly happens to whistleblowers. You'd have the right to challenge that harassment if the government is behind it. This is not an easy right to exercise. You first have to prove that you're exposing something that's a matter of public concern. Then you have to demonstrate that the advantage to the public outweighs the disruptive impact to the organization. Then you have to prove that there was retaliation against you was the predominant motivating factor by whoever you've got a gripe with, that basically read their minds that they're out to hurt you. Then the alleged wrongdoer can still prevail if they prove with a majority of the evidence, which isn't that hard with a government entity, that they still would have taken the same action, even if you hadn't blown the whistle. They're hard to prevail under. But they do get you into court. They do get you a jury trial. You can get injunctive relief. You can get compensatory and punitive damages. And most of all, it's an incredible headache for the school district to have to fight that type of public challenge. So it can be an effective right. The fourth and final right I'm going to share with folks tonight is a law that's called the Lincoln Law, because it was first passed during the Civil War by President Lincoln. And it's called the False Claims Act. This is a law which allows private citizens, anybody in this room, again, not just an employee or not just a contractor, anyone who has evidence of fraud in a government contract or grant can file a whistleblower lawsuit. And in the whistleblower lawsuit, if you prevail, the wrongdoer has to pay back 3 times the amount of the fraudulent contract, and you get between 10 and 30% of it. So it can also be a fundraiser for community organizations. How is this relevant to sexual abuse in the schools? Well, Montgomery County public schools are getting federal funds, quite a bit of federal funds. And as a prerequisite for getting those federal funds, you have to certify that all of the federal money is being spent in a lawful manner consistent with public health and safety regulations. And if there's sexual abuse in the school district, the money is not being spent that way. This means that there's a potential to file a lawsuit challenging the fraud by the school system. They call them key TAM lawsuits. They dated back to the Magna Carta, and it means in the name of the king. It means that we nickname them private attorney general actions. It means as a citizen, you can sue to enforce the law. You don't have to wait for the government to do it for you. That law also has an anti-retaliation provision for anyone who challenges the fraud. So that could apply to a school teacher, a staff person there, maintenance worker, administrative worker, or even a contractor of the school district. Those are sort of the 4 cornerstones of legal rights policies. But I want to share with you that when people come into me at the Government Accountability Project and say, I'm thinking of blowing the whistle, I have to warn them that if all you've got going for you is legal rights, you're in big trouble. It's very expensive to assert your legal rights. It takes a long time. In the meantime, you're probably going to be out in the cold. By the time you win the case, your reputation may be destroyed. You may be financially ruined. The key in what we do at GAP is we don't just do legal cases. We do legal campaigns. In the first stage is knowing the survival strategies so that you don't need a lawsuit. There's a lot of ways to commit the truth, as we put it at GAP. You're treated like you committed a crime and get away with it. That's what we're always striving for, is to help people prevent the retaliation. And thanks to my partner at GAP, John Whitty, I remembered to bring our survival strategies book tonight. They're $20 for the first 30 years of lessons learned at GAP. And it says it's for corporate whistleblowers, but that's just the legal rights section. All the rest of the book is the generic strategies of getting away with committing the truth. And warnings, what you're getting into. So if anyone is really serious about this issue, it's a good primer. probably the most significant survival strategy is solidarity. In my experience, solidarity is the magic word for making a difference, maximizing the impact that you have, making a difference, and minimizing the pain. Isolation is the fatal word. If you're isolated, despite the quality of your evidence and the quality of your rights, you're really, really in trouble. And so I'd like to just give you a little illustration of what we mean by legal campaigns here at GAP. Let's start out. This is the normal dynamic. See this dot here? This is the honest worker, the whistleblower. This circle is a corrupt bureaucracy where they're working when it's abusing its power. So all the pressure is to keep the truth inside that circle. And what do we do at GAP? Well, you know, we're lawyers, but really, we're information matchmakers. We try to unite the isolated whistleblower with all of the stakeholders in society who should be benefiting from that person's knowledge if they only knew what was being done to them. And so we play matchmaker and get their word out to institutional checks and balances, like a government agency and inspector general, the accountability groups, to community citizens organizations, the folks whose families are directly affected by the abuse of power, to the media, that's the lifeblood for ending ignorance and isolation, to relevant law enforcement officials, federal through local, every branch. We want them competing with each other to see who's going to do the best job. The board of directors, institutional oversight of that organization. Congress, absolutely. We should be getting the word out to Senator Cardin, Senator Van Hollen, Representative Jamie Raskin, who's we just came from seeing his father's funeral, Mark Raskin, in downtown today. State legislatures, city and county governments, national NGOs on child abuse, sexual abuse, competitors. Go to the private schools. Let them know about this. We get the word out to everybody who's got a stake in what was being abused. And when that happens, instead of this corrupt bureaucracy surrounding the isolated whistleblower, it's society surrounding that organization. And when that happens, the truth turns into power. And this works. It's worked to stop nuclear power plants. There were accidents waiting to happen. It stopped the federal government from deregulating meat and poultry inspection. It's gotten killer drugs like Vioxx off the market. I won't just get on the soapbox, but this does work, and it's a tactic that's available to you folks. And if you're an organizer, having the Montgomery County Civic Federation is just an incredible blessing for all the people whose families are victimized by this. So you have the capacity to outflank and surround this organization that's betraying your families. That's the tactics of legal campaigns, folks, and they do work effectively. As I said, going to the media is the lifeblood to transcend ignorance. The lifeblood for folks like the Government Accountability Project and you to team up effectively in partnership is evidence. We turn the truth into power, but you gotta have the truth first. That's what we do at GAP. We spend a lot of time doing investigations, helping people bear witness, take statements, make a record, bear witness and make a record, and then confront the power structure with it. We've educated the rest of society with it. It's not so much a lawsuit, it's just working hard to get the truth out. And that's really what I was recruited for by Danila and Linda Shea, is come and talk to folks about your rights, in the School of Teachers' Rights. but really, we're hoping that that's going to put us to work. We're available to take statements from members of the school district, teachers or staff there who are witnesses, from families who have watched the damage to their children, or from children who are brave enough to speak out. We do this under the attorney-client privilege, which means that everything that you share with us remains your property. We're not free to cash in with it. We're not free to go out and save the world with it. We're not free to do anything with it without your advance permission. But we team up with you to make sure that your voice will be the most effective in communicating to the widest possible audience. The partnership can be just unrestricted, or it can be a confidential one. If you want to make, if you're worried about surveillance, or think somebody might be tapping you or listening in or anything like that, don't call us on our regular lines. This is the easy way to get information to us by phone. You can call us on our Signal lines. Get Signal, it's an encryption app, very easily available, it's free for everyone, easily accessible. John Woody and I both have it. I'm going to give you our cell phone numbers now. Our cell phone number for myself, and we didn't want to put it in all the printed materials for it, just to be more discreet if you're trying to be confidential.